Welcome to On the Case with Briffa. I'm Éamon. Today I'm going to speak to you about the monkey selfie copyright case. The case starts with a British wildlife photographer named David Slater, who travelled to Indonesia in 2011 with a view to capturing photographs of the macaque monkeys in their natural habitat. He realised very quickly that this was going to be quite difficult to do, so instead of chasing them around and trying to get photographs of them, he set up his photography equipment, his camera and his tripod in their natural habitat, and lo and behold, they came and took photos of themselves. And not only did they take photos of themselves, but they grinned and they smiled at the reflection that they saw of themselves in the lens of the camera, and the result is this famous photograph of the monkey selfie, which has been widely shared online. So this gave rise to two main issues. The first is, was there copyright in this photograph? And the second was, if there was copyright, who owned it? The US Copyright Office said no. Usually copyright is owned by the photographer, the person who takes the photograph. In this instance, the photograph was taken by an animal, and animals can't have human rights, can't have property rights. The photographer, David Slater, said yes, the photograph was subject to copyright, and he was the person who owned the copyright because he had taken the creative decisions, the setting up of the camera, the choosing of the lens, all those creative decisions that led to the taking of the photograph. PETA, People for the Ethical Treatment of Animals, a charitable organisation interested in animal welfare, agreed that the photograph should be subject to copyright protection, but said that the monkey should own the copyright and not the photographer. In terms of the outcome of the case, ultimately the courts in the US decided that the copyright in the photograph was owned by the photographer, but the parties agreed to a settlement whereby he would agree to pay 25% of the revenues generated by the photograph to animal rights organisations. The first interesting and important point to note is the difficulties and the confusion that can arise when we rely on the default positions under copyright law, because there are lots of grey areas. If you are going to take photographs, or if you are going to engage in any kind of activity that gives rise to the creation of an artistic work, enter into a contract in advance, if at all possible, to deal with the ownership of copyright and to deal with who will have the rights to things like revenue and so forth. The second point to take away is that litigation is expensive and time consuming. So if there is an option for a mutually acceptable or a mutually agreement settlement, that should be given careful consideration. I'm Éamon, and thanks for watching On the Case with Briffa.